Hello, my name is Douglas Guilfoyle, and in this short presentation I want to run quickly through the defences that an accused person can raise in international criminal proceedings. So we're going to be addressing a number of topics, but first we need to get a few key ideas in mind. I'm going to be using the term defences here to cover a number of ideas that allow a defendant to say that they should not be held responsible, should not be convicted in a criminal proceeding. National law would certainly distinguish usually between justifications, a plea that conduct was inherently lawful and hence not criminal, self-defence being the classic example, and excuses. An excuse doesn't contest the fact that conduct was wrongful, but asserts instead that circumstances made the defendant's conduct not blameworthy. Duress and necessity might be the usual examples. This can have consequences, particularly for sentencing or sometimes the status of civil parties and the availability of civil remedies in national proceedings. That is not the case in international law, and the usefulness of the distinction is sometimes doubted, but you'll see it in some of the textbooks you look at. The other thing we should note is that defences are not often expressly pled in the cases. And if we look at defence practice of counsel at the tribunals for Yugoslavia and Rwanda, what we'd often see is that more effort is spent on saying the prosecution has failed to prove its case. And that's usually the better way to run a defence. And so this will include things like challenging witness testimony on the basis that it's uncorroborated or unreliable, pointing to a lack of physical or documentary evidence, claiming that invalid inferences have been drawn from circumstantial evidence, or that exculpatory evidence has not been given sufficient weight, raising an alibi for the defendant, and so on. So concrete examples of cases where defences have been run aren't always easy to come by. And the defences available at the International Criminal Court are set out in Articles 31, 32 and 33. We should note that Article 31.3 indicates that the statute's list of defences is not necessarily exhaustive, and reference to other sources of law can be made under Article 21 of the statute. So the first defence I'll look at briefly is mental incapacity. And here we have an image of Rudolf Hess, a relatively sad figure at the Nuremberg International Military Tribunal. While having been a senior Nazi, even Winston Churchill said at the time of the trial that Hess's case should more properly be treated as a medical one rather than a criminal one. There were real doubts as to his state of mind. In any event, the case law has been set out in the Delalic case at the International Criminal Tribunal for Yugoslavia, saying that a defence of insanity could be a complete defence, but the defendant must establish on the balance of probabilities that at the time of the offence he was labouring under such a defect of reason from disease of the mind as not to know the nature and quality of his act, or if he did know it, that he could not know that what he was doing was wrong. So that takes the standard found in English law in the Norton case, and is obviously a high standard. Less than insanity, the Delalic case points to the idea of diminished mental responsibility, which could be raised in mitigation of sentence and would be available if the defence can prove on the balance of probabilities that a relevant psychological condition existed at the time. The ICC statute takes a different view. So under Article 31.1a, the person must suffer from a mental disease or defect that appears to require something of a physically provable character that destroys that person's capacity to appreciate the unlawfulness or nature of his or her conduct, or capacity to control his or her conduct to conform to the requirements of law. So the point here is there needs to be some sort of physical underlying cause, and the standard is very high. Your appreciation of the criminality of your conduct or your ability to control your conduct has been destroyed, and there is no subset of diminished mental responsibility. The next question is intoxication, and the image I've chosen isn't meant to be humorous. The consumption of intoxicants is a part of most military cultures, particularly during times of armed conflict. So first we can look at the case law. In Vasiljevic, the ICTY trial chamber rejected a claim that the defendant was simply mentally incapable of criminal responsibility because he was a chronic alcoholic. In the Kvoka case, it was held that the intentional consumption of alcohol in contexts where violence is the norm and weapons are carried may be an aggravating factor in sentencing. That is, alcohol is known to lower inhibitions, and in such a context, the willful consumption of alcohol could simply exacerbate your responsibility, not lessen it. Under the ICC statute, Article 31(1)(b requires a person to be in a state of intoxication that destroys their capacity to appreciate the unlawfulness of their conduct or their capacity to control their conduct, unless the person has become voluntarily intoxicated under such circumstances that they knew or disregarded the risk that as a result of their intoxication they would engage in criminal conduct. Points to note here, it's a high standard. Your capacity to regulate your conduct or appreciate its wrongfulness has to be destroyed. It's not available in cases of voluntary intoxication where you knew of or disregarded a risk, but we could certainly consider cases of involuntary intoxication. And intoxication here doesn't just mean alcohol, where soldiers and other combatants are administered drugs. I make the point about child soldiers. They would obviously generally be below the age of legal responsibility at the court, but nonetheless they are frequently administered various drugs. All right, the classic question that then arises is that of self-defense, and here we have a picture of a military training exercise. And this is going to be difficult in many contexts. If in the fog of war you come under fire, potentially from illegal combatants or civilians, what do you do? Do you have a right of self-defense or not? What are the parameters? So, in the Kordich and Serkes case, helpfully, the ICTY trial chamber said, actually the statement of the law found in the Rome Statute is also customary law. So we're dealing with only one standard, it would seem. And Article 31(1)(c) of the Rome Statute tells us that you have a claim to self-defense if the accused person acts reasonably to defend himself or herself or another person, or in the case of war crimes, property which is essential for the survival of the person or another person, or property essential to accomplishing a military mission, against an imminent and unlawful use of force in a manner proportionate to the degree of danger to the person or the other person or property protected. Two key ideas here, really. What constitutes an imminent and unlawful use of force? Dealing with lawful uses of force here, all that's really intended to refer to is legal authority to use force. So you can't exercise self-defense, for example, during an occupation against an occupying authority that is exercising a police function. Under the laws of war, they have the right to use reasonable force acting as police. The question is more imminent. So certainly, this will always be a question of appreciation. You don't have to wait until the blow is struck, but you have to apprehend that violence is imminent. And most of the commentary in case law suggests that that has to objectively been the case. It can't simply have been a perception on your part. And the response must be reasonable and proportionate. Again, this will be a matter of context. But for example, some commentators would suggest that you could only have recourse to lethal force if it were the only available means to safeguard one's own life. But again, I think rather than there being absolute rules, it will be a question for the court to appreciate on the facts of each case. A common question in international criminal law becomes what could be thought of as firing squad cases. What do you do when you are obliged to participate in a crime and the threat is, if you do not do this, you will be killed as well? So this raises questions of duress and necessity. So a classic statement of the law is found in the Einsatzgruppen case from the post-World War II proceedings in Germany in the American zone of occupation. And the formulation there was, let it be said at once that there is no law which requires that an innocent man must forfeit his own life or suffer serious harm in order to avoid committing a crime which he condemns. The threat, however, must be imminent, real, and inevitable. No court will punish a man who, with a loaded pistol at his head, is compelled to pull a lethal lever, nor need the peril be that imminent in order to escape punishment. But the point was, even if the defence is available, it can often fail on the facts, because in the Einsatzgruppen case, the defendants approved of their orders to kill Jews, so they acted under no compulsion. There was no realistic threat to them because it was something they would have agreed to do in any event. Now, a more difficult case is Adamovich. So the facts here is essentially, can a soldier claim a defence of necessity when threatened with execution if he does not participate in a firing squad killing innocent civilians? Now, the majority in that ICTY case laid down an absolute moral postulate: there is no such defence ever. Cassise said, well, no, it's quite clear that there should be a defence of duress in international criminal law because there's a defence of duress in every national legal system. It's just that the exceptions vary. So the question is to work out what the limitations on such a defence are. So he formulated a 4-step test. There must be an imminent threat of severe and irreparable harm to life or limb. There was no adequate means of averting this harm. The act was not disproportionate to the threat, i.e. the defendant chose the lesser of two evils, and the duress situation wasn't voluntarily brought about by the person coerced. So we can think of this as the question, that last point as being, you have no defence of duress, either if you've created the circumstances or you agree inherently with the order. There's no actual threat to you. Now, Judge Stephen, also in the minority, took a very interesting view as to how you calculate the lesser of two evils. Because one might say, well, in a firing squad case, it's a choice of your life or many lives. So obviously, you're not choosing the lesser of two evils to kill many people to save your life. But Judge Stephen said, no, the choice is between, say, the death of 10, 20, 30 people by firing squad, and that number plus one, you as well. So in fact, if you would be killed by the rest of the firing squad, if you failed to comply, then you're not choosing between your life and those of the victims. You're choosing between, as it were, the difference between 30 victims and 30 victims plus one, you. Now, whether that's the correct way to calculate a firing squad type duress situation could be open to debate, but it's certainly an interesting way of looking at those facts. All right, now what does the ICC statute say? Well, the ICC statute essentially agrees with Cassise. The conduct alleged to constitute a crime has been caused by duress resulting from a threat of imminent death or continuing imminent serious bodily harm. The person has acted necessarily and reasonably to avoid that threat, and the person does not intend to cause a greater harm than the one sought to be avoided. So you have this triple requirement of imminent harm, necessary and reasonable action, lesser of two evils. And such a threat can be made either by persons, which is classically how we conceptualize duress, or constituted by circumstances beyond that person's control, which we would think constitute necessity. Our next important category is the question of mistakes of fact and law. Now, these often arise in targeting or planning decisions, which is why I have this particular image here, and we'll come to those in a moment. So, looking first at mistakes of fact, the ICC statute says, a mistake of fact shall be a ground for excluding criminal responsibility only if it negates the mental element required for the crime. Now, this requires you to look at the elements of crimes to the Rome Statute and ask, what is the mental element, and could a mistake change the situation? So essentially, a mistake of fact will only be a defence if it shows that you lacked the requisite mens rea. So, for example, prohibited attacks on civilian or civilian objects is a war crime. So a mistaken identification of a target as a military one and not a civilian one would negate the mens rea, the mental element required for intentionally attacking civilians. It was not your intent to attack civilians, it was your intent to attack a legitimate target. It is controversial, however, to say that you could plead a mistake of fact which, if true, would raise a separate defence. So, for example, mistaken self-defence is a controversial category. But let's think about that. Let's consider a soldier who returns fire in self-defence at a sniper, deliberately killing a civilian he believes is unlawfully engaging in hostilities. But in fact, the sniper is elsewhere. The soldier has killed the wrong person. Now, many would say, well, that's a mistake of fact which, if true, would lead to self-defence. But such a category is not covered by the Rome Statute. I would suggest, actually, that if you go through the ICC elements, you might take a different view, because you have to deliberately attack a protected person. Now, if your mistake of fact is you believe the person is illegally engaging in hostilities, they might be a civilian, but they're not a protected civilian because they're shooting at you, then it's very possible you would lack the mens rea required. So we don't have to ask the question, does the mistake of fact raise a different defence? The mistake of fact may simply negate the precise crime at which we are looking. Mistakes of law. So, a mistake of law as to whether a particular type of conduct is a crime within the jurisdiction of the court, the ICC statute tells us, shall not be a ground for excluding criminal responsibility. A mistake of law may, however, be a ground for excluding criminal responsibility if it negates the mental element required by such a crime, or as we find it in the provisions on superior orders. So this will obviously provide a defence in a case where a legal evaluation is required. So unlawful confinement or unlawful execution as a war crime. The crime itself requires you to know that there's a violation of law. But could it cover a case where a defendant honestly and mistakenly believes the conduct is positively lawful, a mistaken belief in a justification, or cases of ignorance of the law? No, at least not as formulated in the ICC statute. Plainly, the wording of Article 32 doesn't cover ignorance of the law as an excuse. Ignorance of the law is not an excuse. It probably doesn't cover either the idea of a mistaken belief in a justification. And I'll give an example. So Cassese raises in his textbooks a very interesting case. He suggests that after World War II, a mistaken belief in a justification could be a defence, and he looks to the B case. In the B case, British propaganda broadcasts encouraged a view amongst Dutch resistance fighters that it was illegal, positively legal, to execute Nazi collaborators without a trial. But it's hard to see how that belief would negate a mens rea under the ICC elements of crimes. A positive belief that it's lawful to do something doesn't negate the fact that you have willingly killed someone who was a protected person. And remember, you need knowledge of the factual status giving rise to someone's protected status. You don't have to have made a legal evaluation. So while that's an interesting case pointing to a different history and customary international law, Article 32 appears to take the strict view. It covers crimes where a legal evaluation is required, so it will have a very narrow application. Let's now consider the question of superior orders and what you might do in a situation such as that depicted here if you receive an order to execute people in lifeboats who are shipwrecked and therefore protected under the Geneva Conventions in time of war. If anything, in this image it appears that that at least one of the officers might be calling to restrain those below him from doing anything so rash, but equally perhaps it could be one of those situations. Certainly, there's case law precisely on point, but we'll come to that in a moment. First, why have a defence of superior orders? The basic idea here is the soldier's dilemma. So if you're given an illegal order, international law will punish you for carrying it out, but national law will punish you if you don't, because soldiers are expected to obey orders. So it's useful to think of two of the Leipzig trial cases conducted in Germany after World War I that are directly on point. In the Dover Castle case, a submarine commander received faulty intelligence and was told that the Dover Castle, that was marked as a British hospital ship, was in fact being used as a troop carrier. And indeed, the uniforms of some Canadians, medics going on board, apparently looked like the uniforms of artillery officers of a different Allied power. So it was a mistake of fact underlay the order. But in any event, the order was not manifestly illegal to those carrying it out. They were told, plausibly, this hospital ship isn't protected, it's abusing its protection, it is actually a troop transport. Now in the Landovi Castle case, similar facts. There was firing upon a hospital ship, the submarine surfaced and found people in the water, and those people were plainly medics and the wounded, and it was obvious that they had targeted a hospital ship. At that point, the commander ordered his men to machine gun all the survivors. Now that order was manifestly illegal. The difference between the two cases was in Dover Castle, the subordinates were acquitted, and in Landovi Castle, they were convicted, because in the latter case, the order was manifestly illegal, and there was a duty to disobey. And notably, the Nuremberg IMT judgment didn't enter into the question of whether superior orders was an available defence, because it simply said they're not a defence under the Charter. They're specifically excluded by the Charter, but we might consider the question of superior orders as a thing going to mitigation of sentence. Now, how do we look at it under the various statutes? So various statutes reject the defence but acknowledge that could be mitigation of punishment. The Nuremberg Charter, the Tokyo IMT Charter, Control Council Law number 10. The alternative in the ICC statute is a conditional defence. It's a defence under certain circumstances. So superior orders aren't a defence unless A, the person was under a legal obligation to obey, B, the person did not know the order was unlawful, and C, the order was not manifestly unlawful. For the purpose of this article, an order to commit genocidal crimes against humanity are manifestly unlawful. So, under Article 33(1), only war crimes and aggression could be subject to a plea of superior orders. So the key elements here are there must be a legal obligation to obey as a matter of national law. The defendant must not know the order was illegal, but it's going to be hard in practice for the prosecution to negate the defence by proving knowledge of illegality. What's more likely is the test of manifest illegality. Now this is quite a high standard, so it's obvious that you do not have a defence of superior orders where the order was manifestly illegal. What's the standard in the case law? Finter says that the illegality must be outrageous and manifest. That's a Canadian Supreme Court case. In the post-World War II proceedings, the High Command case says that the order must be criminal on its face. And in the Eichmann proceedings in Israel, it was said that the nature of the order must be such that there is, as it were, a black flag flying above it. So all of these descriptions are quite poetic, but not necessarily terribly helpful. They simply suggest that the order must very obviously be illegal. Now, a number of other matters might be relevant to defence proceedings. We'll look at these very briefly. So reprisals have sometimes been raised as a question in defence proceedings. And this is simply to say that the law of armed conflict contains a limited right to engage in breaches of the law of armed conflict in response to the enemy's prior breach. So the enemy has, or the adversary has breached a rule of the law of armed conflict. We will respond in kind, say perhaps using prohibited weapons, but with the objective of inducing compliance. And the law of reprisals can never justify attacks on civilians, so it's going to have a very limited function. Tu quoque is often made as a moral argument, literally meaning you also. So it's a plea that one should not be criminally prosecuted because the enemy, or indeed the powers prosecuting you, have also committed such crimes. While this might be a moral argument, it's never a legal defence. Military necessity. It used to be said that military necessity knows no law. You can do anything if it was required as a matter of military necessity. It's no longer a general defence, but it might be relevant to some very specific crimes under the law of armed conflict, such as civilian displacement, which can be justified by imperative military necessity. Also, consent was an issue before the tribunals for Yugoslavia and Rwanda because sexual offences required that the victim not consent. So pleading that the victim did consent would obviously be a defence. However, under the International Criminal Court, what is required is proof only of coercive circumstances negating consent or lack of capacity. The question of the victim's mental state isn't relevant. However, it's therefore more likely that in an ICC context, a defence could raise a mistake of fact defence, i.e. the defendant mistakenly believed that the circumstances weren't coercive in a manner that inherently negated consent. And that brings us to the end of our short review of the available defences in international criminal law. I hope you found it interesting. Thank you for your attention. I look forward to discussing this more with you in class.